All right. We are going live now on YouTube. So, Jyoti
Hi.
Prakash, you may continue with the initial formalities of the session.
Thank you, Devasis. Good evening, everyone. This is Jyoti Prakash Datta, co-founder, Team Lex Cognoscenti. I welcome you all on behalf of my team to 25th episode of Lex Cognoscenti's Rendezvous series. This series is an initiative to explore the lives, experiences, legal adventures, setbacks, breakthroughs, and legacies of the legal eagles. We endeavor to invite eminent personalities from the legal fraternity and try to be a bridge between you and them. So, continuing this chain this evening, we are honored and exhilarated to be joined by none other than Mr. Jaideep Gupta, Senior Advocate, Supreme Court of India. I welcome you, sir, on board for this interview session. Thank you for joining us.
Thank you very much.
Thank you, sir. Thank you, sir. So, before proceeding with the interview session, I would definitely give a brief introduction of our honorable guest for the convenience of our audience. So, Mr. Gupta is the son of former Solicitor General of India, Mr. Dipankar Prasad Gupta. He studied economics in the Presidency College, Kolkata, and has obtained his law degree from the University of Cambridge. He was designated as a senior advocate in the year 2002. He is renowned practitioner, especially in the fields of civil, commercial, and public laws, and has handled numerous landmark and monumental cases. Recently, the Apex Court has appointed him as an amicus curiae in the suo motu case registered to look after the exigencies caused due to the pandemic COVID-19. So, as the section unfolds and unravels, we'll discuss some other facets of his life and legal career. So, without losing any more time, I would request our co-founder Devasis Kumar Panda to take forward this session and to start with the interview session with the permission of our honorable guest. Devasis, please.
Thank you, Jyoti Prakash. With the due permission of our today's guest, I would like to begin with the session.
Yes, please.
Thank you. Thank you so much, sir. So, beginning with the initial sets of questions that I have. The first question is that I would like to know about your childhood, about your family upbringing, and your schooling days.
I was born in Calcutta in 1961. Um, I was born in a family of lawyers. Even my great grandfather was a lawyer, but of course, I have never had occasion to see him. My grandfather was in the judicial service. Even my grandfather had retired from the judicial service before I was uh, before I have any recollection of him. In my house, there were two prominent top lawyers of Calcutta who practiced. My father, Dipankar Prasad Gupta, and my uncle, Bhaskar Prasad Gupta, who is also a senior advocate. So I grew up with the ground floor of my house being a full law office, a set of 4 or 5 rooms, books on every wall, stenographers crackling away at typewriters at all times of the day and night. And that's the environment which surrounded me all my childhood. I went to school in Calcutta in St. Xavier's Collegiate School, it was called. I was in St. Xavier's till class 12. We were the first batch in this country when the system of class 10 plus 2 was adopted, and I till class 12 I did science. After that, I was in Presidency College. I studied economics, and after I had finished economics, I did my law initially in the University of Cambridge, and then went on to do a professional course, which is, as you know, the bar, the English bar exams, for which you have to be part of a IN, which is a collegiate institution. I was part of Lincoln's Inn. And you also, by my time, it was necessary to take a course, a 9-month course, which in my case I took from an institution called City College, City University, actually, City University in London. And the bar exams, of course, are held by an examining authority called the Council for Legal Education of United Kingdom. And having finished all that, I worked for about 3 months with a lawyer, with a barrister in London, and then came back to India. I started my practice towards the latter half of 1985.
So, sir, after knowing this, I would like to know as to what inspired you to take up law. As you said about your father was in this profession, your uncle was in this profession, is in this profession. So, what inspired you exactly to take up?
Um, your initial impressions of life, very difficult to analyze, I think. As I said, I was surrounded by the legal profession from my childhood days. My grandfather, who was then retired, was of the view that law was in my blood and that when the time comes, I would have no option but to continue with the family tradition. I am not sure he is right because the next generation of my family, my son, has not gone into the legal profession. Um, so therefore, it's very difficult to say what exactly led me into it. It is true that I saw it on a day-to-day basis. I saw the workings of the profession on a day-to-day basis. Both my father and my uncle were role models, and that certainly has a huge influence on you. And while I was studying economics in Presidency College, I was, of course, in two minds as to whether to pursue my study of economics or to go into the legal profession. Fortunately, I had a house full of books and mostly legal books. And legal books included books about lawyers and the legal profession. So in my college days, I read a lot of those books as well to see whether I would uh, I would like to join the legal profession or not. And ultimately, of course, you take a decision. To my mind, it is one of the least calculated decisions in your life, what profession you will go into. One day you just take a road and you stick to it. So that's how it happened.
All right, sir. Now, after dealing with this, we would like to know about how was your experience in your alma mater and then at Cambridge, and any particular advice you would like to give this generation who are aspiring to go to UK or any other foreign university for doing their LLM or who are looking for barristership. So, if you can shed some light on that. But
Um, my alma mater really uh, is St. Xavier's School, which is one of the uh, prime missionary schools of Calcutta. In those days, even today, it has expanded even more today. We were educated by Jesuit fathers who had dedicated their life to educating children in India. And um, even though it was a Christian missionary school, there was absolutely no emphasis on the study of uh, the principles of Christian religion. If you were a Christian, you could study certain aspects of Christianity. But if you weren't, then a very general education was given to you. Apart from that, we had some of the best teachers in our classes. My Bengali teacher was one of the most famous poets of our times in Bengal. His name was Sojol Bandyopadhyay. We had several other very notable teachers. When I moved on to presidency, it was primarily because I had decided to take economics as a subject. And presidency in those days had certainly the best faculty as far as Calcutta was concerned. Maybe it was one of the top economics faculties in the country. And there was a lot of excitement in those days about the subject of economics. It was a very satisfactory combination between science and humanities, because even though it was not a technological subject, it required serious study of mathematics and mathematical principles, and even statistical principles. So we were in Presidency College, we were taught by, again, some of the best professors in the country. Professor Deepak Banerjee, Professor Mihir Rokhit, and many others. I'm not naming them, not because they were any less eminent. I reached Cambridge I think in 1982. And that was, of course, my first exposure to an international environment. Now, Cambridge today is an international university. It does not represent only the United Kingdom. It has consistently been rated as one of the very top universities in the world. And by the time we got there, the United Kingdom was not the head of any empire. It was a country. It was a country with a very significant history. And the university was full of students from all over the world. In the legal faculty itself, we had students from Africa, from Asia, from Europe as well. And there were several Indians, of course. In my batch itself, there were lots of Indians. And it was analytically a very exhilarating experience. The way that a subject is taught to you, a history of teaching which goes back to perhaps the 12th or the 13th century. A very intimate way of teaching in which you have a tutor who takes control of your entire studies, to whom you can refer at any time. You share rooms in the college. The tutors are also having their rooms in the college. We used to have our rooms in the college, so we could walk across to the tutor at any point of time. Cambridge University had 3 sets of libraries. There was the university library, in which all subjects were represented. There was the faculty library, which was, as far as we were concerned, it was the law library. It was called the Square. It was in the middle of the town. And each college also had its own libraries, including, in the case of my college, which is Jesus College, it had its own law library. And Jesus College in those days had some of the best known names in the legal academic faculties. When I joined Jesus College, Professor Glanville Williams was still teaching there. Professor Glanville Williams was then the Rouse Ball Professor of Cambridge University, which is the top chair, professorial chair in Cambridge University for law. And he is a legendary person in the teaching of law. He had written several of our textbooks, and they were amazing people. He used to sit and work across the table in the law library in the college when we were mere students and studying for our exams or studying for the next tutorial, etc. Cambridge had a unique method of teaching. The faculty provided lectures for the entire student population of Cambridge University. The university was split up into some 34 colleges. Each college had a group of students who studied law, and they would jointly come for lecture courses which was offered by the faculty. But on top of the lectures which we had to attend, once every fortnight in each subject, we had what was known in Cambridge as a supervision, which is like a tutorial. And this supervision was a one-to-one supervision. You sat with your tutor relevant for that subject. He or she would give you a project or an assignment to work out in the course of the 2 weeks that would precede the tutorial. Different colleges or different professors had different approaches. Some, as in the case of most of the professors in Jesus College, would give us sheets of questions on a particular topic, and we would spend the time that we had at our disposal to prepare answers to the questions and then go in and discuss the answers. Some professors would, for every supervision, would give you a topic to write an essay on. So you would do your research and write an essay, submit it, and then discuss the essay. Now, this method of teaching is unique to Oxford and Cambridge and to universities in the United Kingdom. It's very different from what we used to do in India, though even in India, even in Presidency College, we had tutorials. But here was a system where students were taught by telling them to go and prepare themselves. One of the most famous economists was John Harrod, who in his time was responsible for basically creating a subject of economics. John Harrod was a historian in his time. He was already a professor in Cambridge when he got interested in the subject of economics. And how did he learn economics? He went to John Maynard Keynes, who was then an economics professor in Cambridge, and said, I wish to learn economics. And the method of teaching economics was that Keynes would give him a subject every few days, and he would go and sit in the library and work and look it up, research it, and come back and discuss the subject with John Maynard Keynes. This is how knowledge is imparted in Cambridge. very similar, of course, to Oxford and several other universities in the United Kingdom. So this is how, in a very, very intimate manner, we learnt the subject. It was not an impersonal lecture that you attended, though you did attend lectures. It was not just an examination, though you did take an examination at the end of the year. But it was a combination of the lecture, the examination, and the tutorial, the supervisions that we used to have one-on-one with a professor, with whom you could discuss anything whatsoever. For instance, I remember that when we were in the tutorials, the film Gandhi was released in the United Kingdom. And on one day, my tutor, Professor Peter Glazebrook, his name was, he told me that he was going to see the movie on the next day. And then he asked me, I have read, he told me this. He said that he had read 3 books on Gandhi already in order to go and see the movie. This is the approach of a Cambridge professor to a movie. So he said, I have read Fisher's biography of Gandhi, 2 other books he said he had read about Gandhi. And then he said, have I missed anything? Is there something else I should read before I go and see the movie? I said, you've missed my experiments with truth, which is Gandhiji's own statement about his life. And he said, nobody brought it to my attention that he had written this autobiography of his. Mind you, obviously, we are talking about UK in the 1980s. In front of our eyes, the approach and the knowledge that the British had about their role in the colonies like India changed in the course of that 1 or 2 years in front of our eyes. So it's not unusual that he had not heard about the book, but when he heard about it, he promptly went and got a copy of it and read. So we used to discuss things like that. In a contract lecture, in a contract supervision, for example, my professor Barry Ryder, with whom I am still in touch, in the middle of the very first supervision, picked out the Indian Contract Act and said, let us see what the Indian Contract Act says about what a contract is. And then he was surprised to find that in the Indian Contract Act, a contract is defined as an enforceable agreement. His first impression was that this is tautological. An agreement is a contract in English law. So why say that a contract is an agreement? But what he missed was, and that became clear in the course of the supervision, because of course I was also at that stage an absolute novice to these subjects. But as we analyzed it, it became clear that there was a distinction between Indian law of contract as laid down in our statute, where a contract is an enforceable agreement, and the English principle, which is that any agreement is also a contract. It may or may not be enforceable, but there is no difference between the word agreement and the word contract. So what I'm trying to get at is that on these one-to-one interactions, we went so much beyond the study of the subject itself. We compared different jurisdictions. We spoke about history. We spoke about other aspects. Sometimes a comment from a professor like that would make you think. For instance, as you know, in our country, in your state as well, Saraswati is revered. And in our student days, the Saraswati Puja day, we did not touch our books. I think that is true of Orissa as well. and the books would be put behind the image of the god and left there. Of course, it was a great day because even parents did not insist on us reading or studying on that day. So when I got there, half jokingly, I told my professor, Professor Glazebrook, that I won't be able to study tomorrow. He said, why? I said, because it is Saraswati Puja. And in our religion, we do not study on that day. Now, I hadn't given much thought to why we didn't study on that day. But he gave it a thought. He said, oh, that's very interesting. Do you try to take inspiration from silence then? Frankly, it is a way of looking at it which had never occurred to us. We took it as a tradition, we just followed it. But the amazing thing about confronting an intelligent person with some aspect of your culture which you have always taken for granted is that sometimes you get a completely new impression of it. So this is how I think we got a very unique education in Cambridge in my time. After that, of course, we did the bar exams. The bar exams was less intimate. It was you attended some courses and you studied and you went and took the examination. It was a professional examination. Only thing was that you had to show that you had attended a course. That's all. In the olden days, when my father and my uncle did the barrister's exam, they didn't even have any requirement of, at least at my father's time, there was no requirement of taking a course. I think in my uncle's time, there was a requirement of taking a course. But by the time we took it, it had become very formal. The system was that before you joined a course, in order to study for the bar, you had to have covered 6 subjects in your university. Or if you had not covered those six subjects by way of a university course, suppose you were studying some other subject like history, in that event, you would have to take a bridging course by taking those 6 subjects, by studying those 6 subjects, because they were the fundamentals of English law. Subjects like contract, constitutional law, criminal law, tort, land and equity. In the UK, in the laws of United Kingdom, land laws have a very special place, and they have a subject called equity, which covers areas which are covered in India mostly by the Specific Relief Act, though not exclusively by the Specific Relief Act. So that was a subject by itself. So you had to take these 6 subjects before you even started studying for the bar exams. Now, in our case, because we did a university program in the United Kingdom, these 6 subjects had already been covered in the course of my degrees, the study of my legal degree. And therefore, I was able to go into the coursework for doing the bar exams straight away. So if there is an area of your question which I have missed out, then please remind me. I'll try to answer that.
Indeed not, sir, but there is a follow-up question that I would like to ask you. In the beginning of your answer, you mentioned about Lincoln's Inn, and you said that there are various inns in which you have to enroll for barristership. So if you can clarify on that part as to what are the inns in London, and how can you enroll in a particular inn and all that?
Yes. So the English bar has this strange institution. Every member of the bar has to be a member of one of the 4 inns. There are only 4 inns. They are all in London. They are all clustered around the law courts. There is the Lincoln's Inn, which is by far the largest of the 4. There is Gray's Inn. There is Middle Temple, and there is Inner Temple. the institution is a peculiar institution. It is a bit like a college. You study there. There is a library. You study there. Some people might live there. In the good old days, people used to live in these inns and study with lawyers. But now the system is that students no longer live in the inns. The rooms in these inns, and these inns are very large. It has Lincoln's Inn had more than hundreds of rooms. Each of these rooms are actually lawyers' chambers. A group of barristers would get together and constitute one chamber. And they would be known as the practitioners of that particular chamber. They would share a common clerk who would administer the office for them. And there would be juniors associated with these chambers. Now, these chambers are located actually in the inns itself. Of course, over a period of time, it was felt inadequate. I mean, in the sense that there were not enough rooms in these 4 inns for the entire legal profession. So then people started buying or renting space outside the 4 inns and for the purpose of setting up law chambers. But there were these common facilities. There were libraries. There was dining rooms. And there is a collegiate practice that all who are members of an inn have to dine together from time to time. Now, the requirement of dining is a method of ensuring that you deal with your peers. That is to say, you maintain a social relationship with all your contemporaries, with all other members of the profession around you. And there are very good reasons why you ought to maintain social and peer-to-peer relationship with your professional colleagues. And perhaps the most important aspect of this is that it is the method by which ethical behavior is maintained between members of the profession. If you socially dine with a person, you're unlikely to be unethical towards that person or rude or impolite, etc. So one of the reasons why this system has grown up is that you are members of a group, and that is how you maintain discipline, that is how you maintain your ethics, etc. So, of course, these dinners had their own formalities, and we had to keep dining terms. One of the curious things about the bar exam is that you are not allowed to sit for the exams unless you had kept 6 dining terms. I think it was 6 in my time. Dining terms only meant that you had to occasionally dine there. That's it. And if you didn't dine 6 times in the bar, in the inn, you could replace one of the dining terms with what was known as, at least in the Lincoln's Inn, you could go away for a weekend to a kind of convention or a conference, you could say, what in today's terms we would call a conference. It happens in corporate institutions in India quite often, where people from one institution will go away and spend some time together. And in our case, I did that because it's a very unique experience. We had a weekend at the Cumberland Lodge, which is part of the estate at Windsor. And in Cumberland Lodge, we spent 3 days. A group of students who were reading for the bar, and there were various programs, there were various exercises there. We had to do debates, we had to participate in various exercises, speaking exercises. and other social activities as well. And that was counted as one dining term. So the idea is to integrate you with other members of your profession, something which we do in this country by sharing, um, by sitting together in a lounge or in a library in the courtroom building. That is a method by which we maintain social relations with other lawyers, and this also helps us in our professional practice, so that some discipline is maintained and people do not, because as you know, it's a very combative kind of profession. You are on a day-to-day basis, particularly if you are a counsel, on a day-to-day basis you are arguing cases against each other. So there is an element of combativeness in this profession, which could easily become ugly if it were not for the fact that every person that we meet and we appear against and we combat it out in court are also very, very close friends of ours outside. And therefore, this is how we maintain discipline in this profession. So it's a unique system. I mean, there are so many things that one can say about it, but it was a wonderful experience.
Indeed, sir. That was quite enlightening, and perhaps this will surely help our viewers to get a brief idea about Cambridge system and then barristership system, as you clearly portrayed now.
Yeah, but
Also, sir,
before we go on, I should warn you that after my time, the system has changed a lot as far as the bar exams are concerned. Not only have you got to take a formal course, as we had started to take, and the examination system, but now it is mandatory to take a advocacy training be part of an advocacy training program, which is called the bar vocational course. And without that, you will not be called to the bar. So things have changed a lot from then till now, but that's a matter which will require a lot of discussion. But it's important that people should know that it has changed since then also.
absolutely, sir. Now I have two things that I would like to ask about the inns that you have said. We have come across terms like door tenant at London and like that. Advocates
So what?
mention that I am door tenant.
Door tenant, yes, yes.
Yes, sir. So, what is that? And are you free to choose any inn? Like as you said, you were in Lincoln Inn, and there are other three inns as well. So, are you free to choose that, or they will choose you in a particular inn?
No, joining an inn was not a difficult exercise at all. People used to choose an inn to join. In my case, Lincoln's Inn was very popular with Indians and has been over a period of time. My father and my uncle were both from Lincoln's Inn, so I chose to join Lincoln's Inn. Joining an inn is not a very difficult exercise. Of course, there may be situations where the inn may not accept you if there is some special reason. But that's a rare situation. Tenancy, on the other hand, is a very different thing. You join the inn initially to take the bar exams. Once you have completed your examinations, you are then called to the bar, which is just a method of saying that you are conferred a degree. And you are now entitled to practice. Of course, the current system, which was introduced for the first time, I think, in my batch, is that merely by taking the bar exams, you were not entitled to practice. You had to do a vocational program thereafter. A vocational program meant a set of you were trained by certain people in the art of advocacy. So it became necessary to do that. After that comes pupillage. Pupillage means a training period with some member of the bar who is already a professional. And once pupillage is over, after that you apply for tenancy. And tenancy means that you are now being admitted to that chamber for the purpose of practicing there. Now, tenancy is a difficult step. That it is like getting a job. You are interviewed by the chambers, and the chambers will accept you or not accept you at their discretion. It is not something which you can generate. It is in fact today very, very difficult to get tenancy in United Kingdom, for the simple reason that there is an explosion of the profession there. It's a small country. Its work is now limited to its own shores and maybe some parts of the Caribbean and some parts of the Commonwealth. They do not have the kind of work that they used to have in the colonial times, when half the world was under their control. But so therefore there is a lot of there is a lot of entry into the profession, and there is not enough space. So therefore today getting a tenancy in a established chamber is very difficult. Of course, you have to meet residency requirements as well. I mean, an Indian cannot just go there and expect to be accepted in chambers, because he is not entitled to practice or work in the United Kingdom unless he has certain qualifications. So tenancy is something which is very different from joining an inn, and it is quite difficult. Door tenancy, on the other hand, is not, even though it does depend upon the chamber and the head of chambers, etc., etc., but door tenancy is not a very, I don't think it's very difficult to become a door tenant. A door tenant only means that you are entitled to use the address of that particular chambers and some facilities, I'm sure, for which a certain fee or certain amount of money is to be paid to them on a yearly basis. We have a few persons in India who have become door tenants only. They do not actually practice on a day-to-day basis from those chambers. But of course, today we have the unique phenomenon of at least, I think, two persons I can of course name, who are actually day-to-day members of chambers proper, and very, very eminent chambers in United Kingdom. Mr. Harish Salve, who is part of Blackwell Chambers on a day-to-day basis. He is not a door tenant. He is a full-fledged member of the Blackstone Chambers. And Mr. Gopal Subramaniam, who is also a full-fledged member of, in Gray's Inn, there is something called Verilius Building, number 3 Verilius Building, if I'm not mistaken. I just offhand do not remember any other person who went from being a practitioner in Indian courts to a full-fledged tenant and a full-fledged member of an English chamber. But there are many more people who are door tenants who actually do not practice out of those chambers, but they maintain a connection with those chambers and they are entitled to use certain facilities there. So these are all very different concepts.
Thank you so much, sir, for enlightening us on these parts specifically. Now, as I have completed the set of questions that I had, I would like to call upon Jyoti Prakash Datta to the studio, and he has certain set of questions related to you, your initial days of the bar, about your father and uncle, and many more aspects he will be dealing with you. So with that, I would request Jyoti Prakash to continue, and I would request our viewers to stay tuned with this particular interview session, and the second part will be quite interesting for you guys to know from our honorable guest, Jaideep Gupta, sir. Thank you so much, sir, for answering my questions.
Thank you very much.
Thank you, Devasis, for asking so many interesting questions. And thank you, sir, for enlightening us with so many lucid and transparent answers. Sir, with your permission, can I start the second phase of this session?
Yes, of course.
Yes, sir. Sir, as we have dealt with a good deal of English system, and we have come to know about the systems in Inns and barristership. So, we want to know from you how has been your experience being a senior advocate in the Indian courts. So, and what is the main difference between being a normal lawyer in India and being a senior advocate?
Could you just repeat the last thing that you said? I didn't get it clearly.
Yes, sir. So, what are the basic differences being a normal lawyer in India and being a senior advocate?
The distinction between a senior advocate and an advocate, or whatever. So, as you know, a senior advocate is designated by the full court of one of the high courts or the Supreme Court of India. And this is done under Section 16, I think, of the Advocates Act. The first distinction, of course, is that it is supposed to be a privilege to be designated, as we call it. And the designation is usually a recognition that an advocate has some special qualities. That is what it is supposed to be. I doubt very much if we senior lawyers are any different in that sense from any other advocate. There are many advocates who are not senior advocates, who are very bright, very brilliant, and who have substantial practices in the bar. Again, it's not a question of age, because there are many people in the high courts who have not, or even in the Supreme Court, who are busy lawyers who have not bothered to take the gown. Now, the senior advocateship is something which we have adopted from a similar practice in the United Kingdom, where depending on whether there is a king or a queen on the throne, a person is designated as a king's counsel or a queen's counsel. So long as Queen Elizabeth II is on the throne of England, of the United Kingdom, I should say, you would become a queen's counsel there. However, if Prince Charles becomes the king, then anybody who aspires to become a senior advocate there would be designated as a king's counsel. Now, it is a privilege which is conferred upon you by judges, because almost in every situation in this country, we adopted the UK practice of the judges deciding based on their own experience and their own whatever they pick up from each other to decide whether to designate somebody or not. In the UK, you then get to wear a silk gown. But in India, you can wear a silk gown, but that is not a significant part of becoming a senior advocate. What is significant is, however, that once you become a senior advocate, you may no longer take instructions directly from a client. So you are now once removed from the client. You have to take your instructions, in any case, from another advocate. There is a difference of dress, but this difference of dress is a little misunderstood in this country. I'm not sure that it is necessary for me to go into it, but something which is common to West Bengal and Odisha is that a junior advocate wears a particular kind of gown, and junior barristers wear a different kind of gown in those days. Now, of course, There is no distinction between a barrister and an advocate in this country. So a junior advocate is at liberty to wear what is known as a junior barrister's gown, or to wear what is known as a junior advocate's gown. The senior advocate's gown in this country is a modification of the junior advocate's gown. It is not a modification of the junior barrister's gown. And all that happens is that a longer hand, a long flap from your elbow downwards is added to a junior advocate's gown to make what is known as a senior advocate's gown. And this has led to some very hilarious confusion in the rest of the country when they see a junior advocate coming from Orissa or West Bengal. And they say that why is he wearing a senior advocate's gown? He is not. He is wearing a junior advocate's gown, but most Indians are not conscious of the difference between that and what is normally worn by a junior advocate in India today, which is a junior barrister's gown. So that is one difference, of course, in the clothing. And the design, of course, is again based on the English profession. It has a curious feature. There is a pocket in the back, and the pocket in the back reflects the fact that we, at least at one time, was a noble profession. I don't know if we are noble anymore. And in a noble profession, you were not expected to demand fees. So therefore, there is a pocket in the back where the client could leave whatever he felt was an appropriate amount of money, and that was it. But anyway, those are all fairy tales basically. Now, not only do lawyers demand fees, they enforce it in many ways, some of which are not very ethical. But anyway, the biggest distinction, as I said, was that we have to remove ourselves from directly dealing with clients and take our instructions from other advocates. The overall the effect of this is that, as you know, an advocate has a duty to the client, and an advocate also has a duty to the court. So he has to be fair to the court, he has to be fair to his client. A lot of people outside our profession and many people inside our profession do not understand the meaning of this distinction. But whatever it is, when you put between you and the client another advocate, then you are able to carry out your duty to the court, I feel, with less hesitation and greater effectiveness than if you were directly in touch with the client and subject to his instructions at all points of time. So it is a system which combines several elements in it. It is a sign of seniority, it is a sign of eminence, it is a sign of detachment from the client, and it is a system which we have got. I have to point out that from time to time there have been objections to the continuance of this system. Even now there are people who think that there should be no discrimination between advocates and senior advocates. But I think that if you look at the system, then there is some logic to it, and it is not really discriminatory in that sense. If there is any aspect to this that you are still interested in, which I have not covered, then please point that out.
No, sir, you have quite exhaustively covered all the aspects of the system, and you have also very lucidly explained the significance of roles of senior advocates and junior advocates. Means only the advocates, we cannot call them juniors. So, sir, thank you for explaining all those parts. And after that, sir, we'll come to your personal life and a bit about your professional life. As we know that you belong to a family of lawyers. Your father was the Solicitor General of India, and your uncle is also a senior advocate. and you have also dealt with many cases involving many legal stalwarts. So, sir, could you share with us some important and interesting conversations or anecdotes that you think that those should be treasured or should be remain in the minds of all the young legal professionals?
Um, I I don't know where to begin because I have had the enormous good fortune of working with almost every leading lawyer of in Calcutta, almost every leading lawyer in the Supreme Court, and not just that, of several other high courts as well. I have uh, I've had the good fortune of dealing with and working with lawyers across the country. So it's almost it's very difficult to narrow down on any one particular incident, etc., etc. Um, the people who are very special to my professional life, apart from my members of my family, and by the way, my father, apart from being the Solicitor General of India, was also at a critical time the Advocate General of West Bengal, and I personally believe that the post of an Advocate General of a state is of great relevance and great significance, just as the law officers of the central government are. So, apart from the influence that of working with uh, him, and I must tell you that I have worked very little with him because the tradition in Calcutta was that even if there was a close member of the family in the profession, in order to make sure that you demonstrated your ability to stand on your own feet, it was, at least in my time, considered to be appropriate not to work too closely with members of your own family. I started my profession in the chambers of Mr. Shamaraditya Pal, better known all across the country as Mr. Bachu Pal. And I worked in his chambers for quite a while. And after I came to Delhi about almost 6 to 7 years after I started my profession. I shifted to Delhi for personal reasons. And when I came to Delhi, I had the huge privilege of working with Mr. K.K. Venugopal, who, as you know, is one of our top lawyers and has been so for decades and is currently the Attorney General of India. I spent almost 3 years in his chambers, and we worked together exhaustively in a litigation which was connected with the security scam in Bombay, which took place in 1991, the Harshad Mehta, where Harshad Mehta was involved. And we worked together on an arbitration between the ANZ Grindless Bank. In those days, it was ANZ Grindless Bank. Now, it doesn't even exist in India. It has become Standard Chartered Bank. But for a while, it was ANZ Grindless, then it became ANZ only. So the dispute which arose out of the Harshad Mehta scam was between ANZ and the National Housing Bank, which, as you may know, is a subsidiary of the Reserve Bank of India. And it related to checks which had been issued by the ANZ Bank in favor of National Housing Bank. Very large checks, total 9 checks amounting to over 500 crores, which in 1991 was a huge amount. Today we don't think of 500 crores as being any figure at all, because most scams exceeded by many zeros. So these checks had been encashed, and the money had been paid over to Harshad Mehta. And when the scam came to attention, the question was how would the money be recovered? And National Housing Bank was trying to recover the money from ANZ to Lisbon. So for years we worked together on this matter, and then after the arbitration was over and the award came, it went to the Bombay High Court, and finally it came to the Supreme Court. And surprisingly, even today, some aspects of this matter are still floating around in the courts, occasionally popping up. So this was not only legally a very challenging litigation for us to handle, it was my good fortune to be able to work on a day-to-day, minute-to-minute basis with my senior, Mr. Venugopal, and to watch him prepare a case, argue it. There is no aspect of the manner in which he prepares a case which I did not get an opportunity of seeing at that point of time. Mr. Harish Salve at one time had said, and this is absolutely true of all of us, the best days of our life, of our professional life, is when we are juniors and we work in the chambers of some senior lawyer. Because that's the time that you learn, that you enjoy the profession, and yet the responsibility of delivering in court is that of somebody else. So it is undoubtedly the best time of your life. And of course, you get paid for it at whatever level you are entitled to. So when I first came to Delhi, this litigation between ANZ and National Housing Bank took up a huge chunk of my time, and it was a extremely formative experience. We have recently lost Mr. Sorabji, Mr. Soli Sorabji, who was the Attorney General of India when I was in Delhi. He made it a point to go out into the corridor and find which juniors he wanted to come and assist him in central government litigation. And I and several of my contemporaries had the good fortune of being chosen to assist him when he was the Attorney General of India. We were panel counsels. Before I became a senior advocate, I was a panel B counsel. After I became a senior advocate, I was a panel A counsel. And with him, I got the experience of handling indirect taxation. He was an absolute master at indirect taxation. Not that he was any less as a constitutional lawyer or as a civil lawyer, and even in certain situations in criminal work. But this area of the law, he knew like the back of his hand. And to have worked with him, we used to have to... the problem with central government, or any government, I think, is that the briefs come very late to you. And so you have to quickly get ready overnight. And we used to then be called for a conference at 9 o'clock in the morning. And at 9, there was very little time before court would sit. So you had to summarize and discuss the case quickly with him. He would make some notes. And his general approach to the subject was so strong that he could pick it up. Mr. Fali Nariman, we have had the good fortune of working with. Mr. Ram Jetmalani, not that much, but still there were occasions where I have appeared with him. I have had the good fortune of seeing Mr. Ashok Sen in the last few years of his practice. He passed away after at the age of 84, I think, a couple of years after I reached Delhi. But the fact was that he was a he was a towering personality and a towering lawyer. Literally towering personality, very tall man, and he was an amazing lawyer. He devoted most of his life and time to the study of the law. So much so that we juniors, who in those days and perhaps even now tend to look upon Friday evenings as our time to take a bit of breath before you get back to work on the weekend for the next week's matters. However, he asked me to come for a conference on a Friday evening, and I found that he was sitting there and making notes from law journals. Now, nowadays we don't have to do this because there is so much software available to us that we can locate judgments very easily. But in those days there was no software available, so lawyers had to make their own notes from journals. And here he was on a Friday evening when most of us juniors were planning to take the evening off. He would be sitting and making notes from journals, and not just Supreme Court journals. I still remember he was making a note of a judgment of a single judge in the Calcutta High Court, Justice Paritosh Mukherjee. And he was making a complete note, and he told me that he has written a very good judgment. It covers this subject very well, and so I'm making a note. His notebooks were quite legendary, and he used to guard them very carefully because he was constantly afraid that people might pick it up and run away with with them. I think he had one or two bad experiences as well. Then there is, of course, the next generation. I had the good fortune of working with Mr. Harish Salve, Mr. Gopal Subramaniam, Mr. Rohington Nariman, who is now, of course, a Supreme Court judge, and many others. They're all legendary. To my mind, they're legendary lawyers, absolutely. And each had a different way of working. Each had their enormous strengths, almost no weaknesses, I would say. And we had to observe, and we tried our level best to emulate their practices. My senior in Calcutta, Mr. Shomaraditya Pal, is very, very knowledgeable on constitutional law, and that was where I got to learn constitutional law first, because having studied mostly in UK, having no Indian law degree, I had to start by looking up the Indian Constitution and studying the law relating to the Indian Constitution, because every other subject that was relevant to me, contract, commercial law, company law, even administrative law, by and large, we follow the principles laid down in English jurisprudence. But the constitutional jurisprudence of India is unique and hardly has any contribution from the English jurisprudence, because England did not have a written constitution. Its principles of constitutional law are derived from old common law cases. It is only now, for a brief period when it was part of the European Union, that it had something like a written constitution, because they had to follow European law as well. But because of that, the Indian Constitution and the jurisprudence which developed under the Indian Constitution is something which any student who has studied abroad must himself learn when he comes back to India. It's a unique jurisprudence. It's very rich, and it has gone way beyond almost any significant jurisdiction that you can think of. We are in a sense world leaders in this subject, in the subject of constitutional structures, etc. So my initial training in constitutional law was with Mr. Pal, and with him I learnt the intricacies of challenging a legislation. Recently, you might have seen that when WhatsApp challenged the law in the Delhi High Court, or rather the guidelines, I think, when they challenged the guidelines relating to information technology, somebody commented, and I don't remember who it was, who said that challenging a law is an insult to the government. It's nothing like that. From the days of Madison and Marbury in the United States, the principle of judicial review of legislative action is a legal tool. It is a legal tool by which the constitutional courts, which in India includes the Supreme Court and the High Courts, it's a legal tool which allows the court to review whether a legislation is valid constitutionally or not, whether it violates any principle of constitutional law. Is it discriminatory? Is it violating any of the safeguards in Part 3 of the Constitution of fundamental rights, etc. Whether it is violating the competence of the legislature which has enacted the law. Is it within the state's power or is it within the power of the union, etc., etc. Now, the strongest training that you can get in this is if you watch or if you participate in a litigation where a legislation is under challenge on the ground that it violates the Constitution of India. And I got an opportunity to see that very early on in my career. The Calcutta Thika Tenancy Act, which is a law for acquisition of lands, lots of lands at that time in Calcutta and Howrah. Now it covers the whole of West Bengal. It was acquired, and Mr. Pal was appearing before a full bench of the Calcutta High Court, that is 3 judges. And we had to work out that. As a result of that, all the fundamental judgments of constitutional jurisprudence had to be gone through. Article 14, 19, 31, all these were involved. And it became a primer for me, which clears your concepts of constitutional jurisprudence. So, one can go on and on. There have been so many litigation that we have, that by now I have done. And after the cushion of having a senior was taken away, there have been many matters where I had to take up the responsibility myself. Matters relating to Article 25 and 26 of the Constitution, which deals with the rights of Indian citizens to practice their religion, and the conflict between that right and the right of the state to control certain aspects of secular aspects relating to religious institutions, and also the conflict between that and the rights of secular religious institutions themselves. So there was the Sabrimala case, there was the Tiruvananthapuram, the Padmanabha Swami case, there was the litigation relating to the Kamakya Mandir in Guwahati, and many others. So recently we have finished a very important litigation relating to whether Indira Sawhney's judgment requires to be re-looked at. And the answer was that no, it is not to be looked at. Amendments 102 and 103 of the Constitution was considered, and a decision was given, which of course is controversial in today's light, that after the amendment to the Constitution, the primacy with regard to deciding what is or is not a protected class, scheduled caste, scheduled tribe, or backward classes, lies with the central government, and the states are not do not have a right to decide these questions. This is, of course, a very controversial issue just now, and we will see where it ultimately takes us. And many others. I mean, it's impossible to sit here. The law of arbitration, which is very close to my heart, literally hundreds of arbitrations and cases which went to court after that. The huge reform which came in 1996 with the new Arbitration Act, and how the courts have interpreted it. Sometimes, in our opinion, the court has not followed the ethos of the reform. The ethos of the reform was to limit judicial interference, but the way that the jurisprudence has developed on the arbitration law is the opposite of that. And for good reason, judges decided that no, it cannot be a hands-off approach. They needed to maintain their right to look at the award in some detail. Litigation relating to companies, some indirect taxation, as I told you, etc. So, a lot. And nowadays we have sometimes perforce to take up criminal litigation, which is a subject which I never did as a junior. So I have to, if I have to do it, it requires even greater effort on my part. It is something that I have to relearn, or rather learn from scratch before I go into court.
Indeed, sir. It was quite interesting and enthralling to know all these things from you. You explained about the important cases that you have handled. You explained the way of working of legends like Soli Sarabji and Mr. Ashok Sen, who was also the former law minister of our Union of India. And all these things were quite interesting to know, sir. And sir, after that, I have an interesting question for you. As we know that you belong to a lawyer's family, and being backed by such legendary figures, there was less number of challenges that you had to face. But still, you must have had your own sets of challenges. So, what are those challenges, if you can mention for us?
We think that it might give you a few months of comfort if you come from a legal background. People might know of you. They might have seen you growing up. You might have access to a law library from an earlier age than those who are first-time lawyers. But the thing is that until and unless you develop your own ability to do the work, clients will not be coming back to you. So it is an advantage. I won't deny it. Even today, I sometimes get introduced as being the son of or the nephew of. But within a short period, you have to perform on your own. Otherwise, there is no dearth of persons who have entered the profession from very, very legally illustrious backgrounds who did not survive in the profession. So it's an advantage, but it is an advantage that you have to build upon. And if you do not build upon it, then there is no, then it does not serve you for the rest of your life.
Right, sir. And as we are running out of time, I have only two questions for you, sir. First question is related to your personal life. As what you prefer to do when you have nothing to do, like any legal research, and especially what is your pastime activities and hobbies?
My my biggest uh, what gives me the greatest peace, I would say, is music. I'm very fond of all forms of Indian music. I am not that knowledgeable about Western music, though my friends and my generation have are usually very knowledgeable about Western music. Um, so any form of Indian music I like. It can be classical, it can be um, Bollywood, it can be in any language. If I understand it, good. Otherwise, I listen to the tune. This is my principal hobby. It is my principal solace. I My musical instruments are in my study, even in this room as I speak. And when I get fed up of my papers, I hop across to a little corner that I have there and take up music. So that is one thing. Other than that, of course, we grew up at a time when we were not really encouraged to watch television, though we are now doing an enormous amount of it. So therefore, reading was books was both fiction and non-fiction was a part of my life from childhood days, um, and it continues to be so. My favorite subjects of non-fiction are history and biographical works, because that operates as a method of, what should I say, training yourself. To read about how somebody else does something is a matter of training for yourself as well. So yes, currently I am reading Howard Zinn's People's History of the USA, a very famous book which looks at the American history not from the point of view of the governments, but from the point of view of common people who suffered under it. Um, and at the same time, I'm reading an autobiographical work called The Promised Land, which is the first part of Barack Obama's autobiography of his life as a president of the United States. And a little bit of fiction is going on also on the side. Fortunately, we have the ability now to spend some time reading, because the Supreme Court at least is closed now, and once it is open, the windows of opportunity go down a little bit. And then, of course, at the drop of a hat, I like to travel. Uh, I was thinking the other day as I was organizing my photographs that till now, the year in which I have traveled most was 2019. It is almost as if there was some premonition that for years after that, I would be stuck at home and would not be able to travel. So I found as I went through my photographs that 2019 was the year when I went to Scotland. I visited parts of France. I went to Zambia on a conference. I visited Cambridge, which I do once a year on a conference. My son is in San Francisco, so I spent some time with him there also. And even within this country, there are certain favorite spots like Puri and Darjeeling, which I did visit in that year. So it's a little startling how one almost had a premonition that for years we won't be able to travel again.
Quite interesting to know your love for music, traveling, and reading books. We are really inspired by all your hobbies and pastime activities, and I am very sure that who all are watching us today will get some inspiration to pursue these kind of hobbies, because these kind of hobbies are going to help us in the profession as well. And sir, before parting with this particular show, I will ask you another question about your personal life, and also it is also related to your professional life. You have done so many. You have done so many hats. You have done several cases. You have worked with several legendary figures. Do you have any regret in your life that you couldn't do one thing and you want to do before uh, taking the last breath?
I am happy to say that we don't have to retire in this profession. So if something has not yet been done, there is a lot of time left to do it. At least nowadays, we cannot be sure how long we have, but so long as we have time in our hands, we can still cover up whatever we haven't been able to do. But I am not, today, I can't offhand think of something which I have not been able to do or which I regret not being able to do. Um, God has been very kind in that regard. And by the way, the before I move away from the topic of reading, there are a lot of legal literature written around law. It's not legal literature. It's not about the law. So, for instance, novels and Charles Dickens novels and other literature which is um, John Galsworthy and all that, which is written about lawyers. So there is a chapter in a book by Glanville Williams, the last chapter of his book on learning the law, which talks about literary uh, allusions, where literature covers legal issues. And that chapter, I would say, if anybody is aspiring to be a lawyer, one should look into. In recent times, there has been Rumpole, the character Rumpole. John Mortimer is the author. Before that, there was Henry Cecil. There is, in my language, in Bengali, there is Koto Ajanare, which is the experience of the author himself, Shankar, who is an award-winning author, who started life as the clerk of an English barrister in the Calcutta High Court, Lord Barwell, Mr. Barwell. And the book is about his experience as a clerk in the Calcutta High Court in those days, in the 50s, I think. So there is a lot of literature which is surrounding this profession, not legal reading. So I would really encourage lawyers to read all that stuff. Charles Dickens is, of course, the most famous author in the English language who has written enormous amount of work on the legal profession. And there are many others.
Definitely, sir. It will help every person who are listening to us to read all those literature relating to law and also relating to other aspects of disciplines. So thank you, sir, for giving us so many inputs, so for providing us with so many anecdotes and giving us many facets of your life. So before parting with this particular show, I would request Devasis to come on the screen and to give a vote of thanks to our honorable guest. Devasis, please.
Thank you, Jyoti Prakash, for calling me in. As we have come to the end of today's session with our honorable guest, I must say that it was one of the most enlightening session of our Rendezvous series. And with that, I, on behalf of Team Lex Cognoscenti, would like to mention my deepest sense of appreciation for our honorable guest, Mr. Jaideep Gupta, sir, for sharing a number of I must say number of pointers, number of valuable infos which will help countless law students in every way. which we think of. So thank you so much, sir, for joining in and sparing almost 1.5 hours of your valuable time from your busy schedule. And we are really grateful to host you today, to learn from you directly. And I am sure that this will be treasured and remembered by everybody who views this particular video in future and who are viewing this now for the time being. So thank you so much, sir. We are really grateful. We are really privileged, humbled, and thrilled by your presence in the today's evening's interview and talk. So thank you so much, sir, for joining.
My
Thank you.
pleasure. Entirely my pleasure. Thank you very much.